again. Okay. So this is a portion that we are learning about recognition and enforcement, right? Under Article 35(8), regardless of which country the arbitration was made, it will be recognized as binding. For example, it could possible that arbitration was an international arbitration and that was taking place in country A, and the parties were from the countries B. So because of the award was made into the country A, it doesn't mean that it will not be applicable or binding in country B. No. Regardless of where it has been made, it will be binding in whosoever country the parties are belonging to. Are you clear on this fact? Second thing you have to look around is that upon application in writing to the court shall be informed subject to the previous of the article. So what does it mean? For an example, this is a common statement which is need to be there in writing. Even when you want to appeal to cancel the award, okay, to cancel the award, to grant the award, everything should be in writing, and there is a time period in which you have to give in the notice. For example, when we are going to award, so like we have been through some of the days, that 60 days, 30 days. So this is what they're stating, that upon application and writing to the court shall be informed subject to the previous of the article. So the previous of the article, something that we have been through, that kitne days rehte hain, that we have to ensure. Okay. Under Article 36, recognitions of enforcement of our arbitral award, recognitions means the parties are agree and they are going to follow it. If the parties are not agree, or the one party is not willing to pay the award to other party, the claimant, in that case, it would become the enforcement. So that is what the recognitions and enforcement does mean. Okay. Recognition means that parties are okay and they are going to willingly accept that, and they're going to apply or probably be giving the award to the party who is basically the claimant. Otherwise, it will be the enforcement. Okay. Under Article 36, recognitions or enforcement of arbitral award, irrespective of the country in which was made, may be refused only. Refuse means it can only cancelled because of the following reasons. Now we will be learning about the A and the case study about the B. So there are certain facts that we have to take care of. In the A, there are the 5 factors that we have to take care of. 1, 2, 3, 4, and 5. Okay. And the B, they are the 2 factors that we have to take care of. Now, I have just taken some of the explanation from here, and I think I will be explaining this to you. Can you be able to see the Copilot screen, the summary which I have made for you?
Yes.
With the help of the AI. Hello, both of you.
Yes, sir.
Yes, sir.
So basically, the main rule is that the one we have been through, that recognition or enforcement of arbitral award, respective of the country in which it was made, may be refused only because, meaning it does mean the same, that court must generally enforce arbitration award. Must generally enforce mean they will try to ensure that key award, whatever the award, it should be completed. Otherwise it will become enforceable, or there will be some consequences, right? No matter where the award was made, but they can only refuse in a specific situation. If we talk about the specific situations, so there are the 5 situations for the A. At the request of the party against whom it was invoked, if that party furnish proof, that this means that losing party can ask the court not to enforce the award, but they must prove one of the following. Now, who is the losing party over here? It is the defendant or the claimant?
Defendant.
Perfect. Now what happened, that claimant has claimed something and arbitrator has given the award to them. The defendant party has lost that, and now the defendant party might appeal to the court that, and they can ask to not enforce the award. It does mean that they will be looking forward to cancel the award which they have to pay to the claimant, right? Why this could be a situation? Because it could be because of that the party, the defendant, might not be thinking that they have proved this is right. They would be thinking this is a wrong. The wrong justice has been given to them, right? The award should not be awarded to the claimant, right? This is what their thinking should be in the particular situation. So what are the things that they have to prove? A party to the arbitration agreement referred to in Article 7 was under some incapacities, or the sad agreement is not valid under the law to which the parties have subjected to it or under the law of the country where the award was made. Explanation is that if one party was legally incapable, what does it mean? That mentally unfit or minor, or the arbitration agreement itself was invalid under the applicable law, enforcement can be refused, right? Now the a first point says that if the party, either of the one party is mentally unfit or they are either minor, okay, either they are mentally unfit or either they are minor. In these two cases, it may be a situation where the refusal can be there for the enforcement of the award. First thing. Second point, they're talking about that if the arbitration agreement between the two parties it's itself invalid, in that case, the enforcement can also be refused. Have you understood the first line? Hello.
Yes, sir.
So probably you can see from here to here, this is might be a little wide to understand from here. And ultimately, you do not have to learn the things or the fact or the definition of the terms with this given here. Like in refer to the accordance article, this is something you will not be required to learn. Okay, until and unless there are some rules or regulation of the partnership act. Okay, if those are the major act, then you have to remember. Otherwise, the single particular act or article something you do not have to remember. The article or section something you do not have to remember. Okay, remember the act or that would be more than enough. Okay, like we have an IT act, that we have a partnership act, like we have a LLP act. Okay, those things need to be remembered. Second point that they're talking about, that the party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or of the arbitral proceeding, or was otherwise unable to present his case. Right now, they're talking about the three situations. What are those? Whether they were not given the proper notice for the appointment of the arbitrator. First thing. Second point is that of the arbitral proceeding. Proceeding means when the this is the exact meaning of adjudication. This is basically the process when you are hearing the case into the court, right? So when your case has started into the court or the arbitration, it does mean that adjudication is started, and this is exactly the same in what the arbitral proceeding does. Okay, and was otherwise unable to present. So either they were not having a proper time or proper information, proper notice of the appointment of the arbitrator. Second thing, they would not be having the arbitral proceeding. Third thing was that they would not be able to present his case. So in that case, you probably be knowing that if some party would not be having the side to speak about themselves or present their case, so in that case, the justice probably be the one who is not satisfying or justifying, right? Yes. Hello. So in order to ensure that the award or the justice which has been given by the court or the arbitrator should include both parties' fact, both parties' side point of view, right? If we look to the explanation, it says that if the losing party was not properly informed about the arbitration or could not participate fairly, the award may be rejected. Why? Because one party has given all the proof, other party has not given all the proof. They might not be able to present, or they would not be having enough time to present. So you are forming, as an arbitrator, you are forming a decision on the basis of the half information which is presented to you, or you're forming a decision on the basis of the information which is only presented by the one party. Have you understood these 2 points? When the possibility of invoked is there, when we can appeal that the award can be cancelled out. Hello, both of you.
Yes, sir.
If we talk about the third point, which is here, the award deal with the dispute not contemplate by or not falling within the terms of the submission to the arbitration. If the arbitrators decide on issue that weren't part of the original agreement to the arbitrator, the part of the award can be refused. Now, this is one thing to note, that sometime you will see that all the full award will be cancelled or the part of the award will be cancelled. What does it mean? Any one of you please explain the meaning to me?
So either 1 minute.
Yes, please. Shrikant, you're doing good. Please.
Yeah, so if there was an original, so if the arbitrators were deciding on the issue and some part was included which was not part of the agreement of the things that were supposed to be decided, that part of the award can be refused. But if there is no distinction between the part that was agreed to be arbitrated and the part that was not supposed to be arbitrated, then the valid part is still enforced.
Good, brother. And if I ask you one thing over here, what can be a situation where the invalid part or valid part cannot be separated? What can be a situation? Just any example that you can think of. It would be implied or implied, or it would be implied or expressed that we say. Hello.
Implied.
Wonderful. Siddhant, I really would like to appreciate your efforts, your attention towards the class. Even the Samvit answers so a lot, but the way you're thinking is something too good. The implied is because Samvit, are you there?
Yes, sir.
So some implied is because ultimately now you will see that the case goes to the court, okay? And when the judge or the arbitrator is looking after the case, they probably be thinking that this is something implied that will always be applicable. Right? That implied is something that might not become the part of the original agreement. First thing. Second thing, because it is implied, the judge or the arbitrator would be applying that by themselves. Yes or no? Agree on this or not? Samvit?
Yes, sir.
Hana? These two things are so?
Yes.
Now,
Yes.
now, when the implied things is implied it, and that is assumed that is will always be there in the case, and if that cannot be separated, or if that proof later on invalid, and if that cannot be separated from the valid one, in that case, the part which basically got influenced, the part of the award which basically got influenced because of the implied rule which has been used by the arbitrator will still be enforced. Have you understood, both of you, Siddhant and Samvit?
Yes.
Again, I really
Wonderful.
appreciate Siddhant. So you know the approach, you know how you have to think when you're studying about the ACCA, and that because you have passed some of your ACCA papers, so you know the approach that you have to tackle and what is basically they try to put into. So from where you have done your bachelor's?
Christ University, Bangalore.
Wonderful, wonderful. I was thinking about it. So if I talk about the next point that we do have, the fourth one, the composition of the arbitral tribunals or the arbitral proceeding was not in accordance with the agreement of the parties or the law of the country where the arbitration took place, right? What does it mean? The composition of the arbitral tribunals or arbitral proceeding. So there are the three things. Now you know that what is an arbitral tribunal, what is an arbitral proceeding, and what is an arbitral agreement, or what is an arbitrations process, and what is an arbitrator, right? So you must know the difference between these 4 or 5 things, right? They might not be asked you the definition of them, but better you know, because ultimately this will further help you in reading the case studies in an effective way. Okay. If the arbitration process or the way arbitrators were chosen did not follow the agreed rule or the local rule, enforcement can be denied. Okay. Hello.
Yes, sir.
Yes.
Done. Now, Samvit, what can be the reason or the difference between something which is rejected or something which is denied? Probably the same meaning, but if there is anything that we can differentiate between the two.
So what is your question?
I want you to know they are the two words like denied and rejected. So what can be the difference between the two?
Not sure.
Okay. So denied is mean that it is the timing. The timing basically makes the difference between the two. Denied is something you are starting something and you already denied it. Okay, I'm not going to work on this because this is something when you have a doubt on the eligibility of something, denied would be coming. Okay, but when you started the processing, okay, and when you come to know that something is not complete, something is inappropriate, in that case you would be doing the rejection. So when you are doing when you are cancelling out at the start of the proceeding, in that case it would be denied. And when you have done something, when you have given some time of yours, in that case if you are then cancelling out, it would be rejected. Okay, now can I ask both of you to just read this sentence? If the losing party was not properly informed about the arbitration or the could not participate fairly, the award may be rejected. Now the award has been given, Hana. Hello. In this case, the award has been given, but award will be rejected. Why? Because the party was not properly informed about the arbitrations or could not participate fairly. That's why the award will be rejected, which was before awarded. Okay, have you understood? Hello.
Yes.
Have you got what I mean to convey by this sentence? Hello, Siddhant, are you there?
Yes, sir.
Okay, if I ask you this, would it be okay, Samvit, to read this statement? This one.
If the arbitration process or the way the arbitrators were chosen didn't follow the agreed rules or local law, enforcement can be denied.
Yes. So when we are going to look forward towards the award, okay, or when we look to check on some eligibility portion, like whether the arbitrator was chosen correctly, whether they have followed the local rule or not. If they have not followed, then we will not be even looking after what is the case, what is the award has been given. Okay, so it is enforcement will be denied at the starting when we got to know that arbitrator was or other arbitration process was not followed correctly or with accordance with the local rules. Okay, or the other agreed rules. Okay, hello, is it okay?
Yes, sir.
Yes.
The award has not yet become binding on the parties or has been set aside or suspended by the court of the country in which that award was made. Okay, if the award is not final yet or it has been cancelled or paused by the court in the country where it was issued, it won't be enforced elsewhere. Okay, what does it mean? It could be a situation when the party has been given the award, but now the court has pushed it on to a position when they have said that okay, just keep it on the hold and we will be looking into that matter later on. In that case, it will not be enforceable. Okay, if I just look on this area, the second portion, if the court find that now even if the losing party does not object, the court itself can refuse the enforcement, but it's still here the court, if the court find that can only be possible. The subject matter of the dispute is not capable of the settlement by the arbitration under the law of this state. It does mean that suppose every country would be having some authority and the authority would be defining the limitation of the power and right that the country would be having. Okay, so one cannot give the order, one cannot give the the orders, the command over to the powers. This is something we all see across around us, right? So some issues like criminal matters or the family laws in some countries cannot be settled by the arbitrations because arbitration does not have a power to settle the family and criminal issues, right? If that the case, the award won't be enforceable. Okay, the recognitions and enforcement of the award would be contrary. Contrary means something opposite to the public policy. But this is it. If that goes to the against or the if that goes against to the public policy, if the award goes against to the public policy, in that case it will not be enforceable. If enforcing the award would go against the country core legal and moral principle, the court can reject it. Okay. And second thing, some issues will not be dealt through the arbitrations. So if those are the issues, in that case, they can't be enforceable. So now a question will be there, and they will try to ask you for court specifically. They will ask you which one or which two are for the court. Okay. So where the possibility would arise, where the possibility will be there, when you will see that the court himself would be coming onto the front and cancelling out the award which is given without the objection of the losing party. In that case, you will be talking about you will be looking forward to this point. Okay, The 5 of the point would come when the losing party is going to give the objection. Are you clear on this point? Hello,
Yes.
both of you. If you just quickly get you through from here as well, so you would be familiar with the point. There were so many little things which you need to know. So I have taken extra time for the thing. I was not able to explain you yesterday. So if I start from here, it says that under the Article 36, recognition or enforcement of the arbitral award, respective of the country in which it was made, may be refused only at the request of the party whom it was invoked and by the court itself. Okay. If we talk about the party against who it was invoked, a party to the arbitration agreement referred to the article was under some incapacities or said agreement is not valid under the law to which the parties are subjected or failing any indication thereon under the law of the country where the award was made. The party against whom the award was invoked was not given proper notice of the appointment of the arbitration or the arbitral proceeding or was otherwise unable to present his case, right? The award deals with the dispute not contemplated by or not falling within the terms of the submission of the arbitrations, or it contains decisions on matters beyond the scope of the submission to the arbitrator. If that is the issue, in that case, the arbitration cannot give the solutions to that. If the decision or the matter submitted to the arbitration can be separated from those not so submitted, the party of the award which contain decisions on matters submitted to the arbitration may be recognized or influenced, right? The composition of the arbitral tribunals or the arbitration proceeding was not in accordance with the agreement of the parties. Failing such agreement was not accordance with the law of the country where the arbitration took place. If we talk about the last one, the award has not become binding. In that case, it could also possible to cancel out by the party, but the objections are required by the losing party. If the court find any of these 2 points, in that case, without even the objection of the losing party, the court can dismiss or either reject the award which is basically given to the claimant, right? The subject matter of the dispute is not capable of the settlement of by the arbitration under the law of this state. The recognitions or enforcement of the award would be contrary to the public policy of this state. So this is basically the thing that we are supposed to do. And now, any one of you, please help me with this. With this cues. Pepsi company make a very popular soft drink. This flavor mix for the soft drink is highly secretive. They are concerned that a forthcoming legal procedure may require them to devalue their formula. So yesterday when I was talking about that, arbitration is basically the place where the business comes to look for the resolution for dispute, because they basically deal into their very secretive or patent things. If they would be going to the court, then they might lose their because ultimately whatever case goes to the court, it will becomes public, Hana? But this is what not happen in the arbitration. Just to keep the privacy, the arbitrations is something the choice of the major business, right? So what should they do? They should approach the court for the field trial. Nothing their beverage is too good to be copied. Approach an arbitration. So which one they should do? Hello. Which one will be the
arbitration.
Is this Samvit? Hello.
Yes.
Done. Wonderful. An arbitration award can be challenged within of that award, and if asked if justify the tribunal will make additional award within. So what is that? Was it about 13 days or what? So there will be 2 days that will be coming up. I really don't remember the days. This is something you can only learn. Okay. Which of the following is a subsidy of the UN? D. Okay. That was about some justice related. If we talk about the last fourth question that we do have, Jonathan and Roy are the 2 arbiters who cannot agree upon the third arbitrator within. That's it in that case. So who will appoint? If 2 arbitrator cannot be done, so who is going to appoint the arbitrator, the third arbitrator? So it will be from the government.
Option C.
Hana?
Option
30 days
C.
in court of the relevant. Done. Wonderful. Okay. if we quickly go through to some of the questions from the Kaplan. So we have attempted some of the questions from the Kaplan itself, है ना? Siddhant, have you done from till when you like what is the number of the question that you have attempted from the Kaplan?
I don't remember. I did the first, the business, the first one I did.
So you were saying that you have completed till now. You have not something like this, huh?
Yeah, I think the first like 40 questions or something like that.
Done. So we'll try some questions from here. I think we have attempted some of the question before as well, Hana?
Yes, sir.
Yes.
So, were you able to? I think this is something an important question which you should know. In relation to the English legal system, I hope you remember something is binding. If you're going to follow the previous judicial precedent, the previous decision of the court, in that case, something is binding and something is persuasive, right? So, what will be the binding thing? This is a question about. In relation to the English legal system, which part of the legal judgment establishes the precedent that is to be followed by the lower court? So, which option is this? The ratio descending, the fact that it considered important by the judge, or what? The ratio descending is one of the one. The ratio descending will be the one. This is the main reason why the fact has been given. This obiter dicta is basically the hypothetical situation, right? Okay. So I will be joining this class again without a break so that we can cover some of the questions from the Kaplan BPP, and then I will hand over this chapter to you, and then we'll start with the agency. Is it okay? The next class will be next 20 to 30 minutes just to cover on the questions from the Kaplan, and then we will be free from this this side, okay, from these two chapters. Is it okay?
Okay.
Done.